Hello, everyone. I'm Jessica Goldstein, Education Program Coordinator at ASRM. Before beginning the webinar, I'd like to go over a few housekeeping items. To make sure we can cover all the content in the allotted time, everyone's line except the speakers will be muted. We'll devote about 15 minutes at the end of the presentation to questions. Please feel free to type a question in the chat window at any time. We will then read as many selected questions as possible to the presenters during the allotted question and answer time. A recording of this webinar will be archived on the ASRM website in the coming weeks. Please watch your email for notification. To introduce our speakers today, I'll turn things over to Professor Judith Darr, Chair of the ASRM Ethics Committee.
Thank you so much, Jessica. Hello, welcome. Good evening, good afternoon to our guests, and we're just delighted to have you on board for our quad-annual ASRM webinar. Today, our webinar focuses on the topic of cross-border reproductive care, and it's titled Current Trends and Continuing Dilemmas. Now, as perhaps everyone on the line knows, this topic has become of increasing interest and concern in the world of reproductive medicine. As our social and economic practices become more global, so too does the practice of medicine in general and reproductive medicine in particular. Cross-border reproductive care describes patient travel outside of their state or country of domicile to seek reproductive medical services. This conduct raises legal, ethical, and clinical questions that are the subject of today's presentation. Today's three speakers will speak about their perspectives on the dilemma of cross-border reproductive care, each addressing a different aspect of the practice. We intend for the presentation to unfold in three parts. First, we'll hear from Professor Glenn Cohen, and he'll speak about patients with passports, medical tourism law, and ethics. Glenn is a professor of law at Harvard Law School and the director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics. Glenn is a highly published and well-regarded scholar in the health law field. He's published nearly 100 articles in such prestigious journals as the Stanford Law Review and the New England Journal of Medicine. Recently, his cutting-edge scholarship has looked at emerging technologies, including germline genome editing, as well as mitochondrial replacement therapy. We welcome Glenn to our ASRM community. Next, we'll hear from Nidhi Desai, who will speak about legal aspects of cross-border reproductive care. Nidhi is a partner in the Chicago area law firm of Desai and Miller, which specializes in the law surrounding both adoption and collaborative reproduction. Nidhi is an advocate, and she was one of the architects of the Illinois Surrogacy Act, which was passed in 2004, and many of us know facilitates these collaborative arrangements in her state. She has served as chair of the ASRM Legal Professionals Group, as well as a fellow of the Academy of Adoption Attorneys and the American Academy of Assisted Reproductive Technology Law Attorneys, or ARTA. We welcome Nidhi. Finally, Dr. Joe Davis will talk with us about the globe-trotting patient clinical scenarios in cross-border reproductive care. Joe is a board-certified OBGYN and reproductive endocrinologist. He's currently a physician at Reproductive Medicine Associates of New York and Mount Sinai Hospital. He also serves as an assistant professor of OBGYN at Michigan State University. Joe has worked with the World Health Organization Guideline Development Group to address legal and human rights in the provision of fertility care. And perhaps most importantly to me, he is an incredibly productive and valued member of our ASRM Ethics Committee. So that gives you a bit of background about our speakers, and Jessica mentioned some of the housekeeping details. Let me just review two. First, each presenter will speak for approximately 12 to 15 minutes in the order that I've just introduced them. And second, importantly, we welcome your feedback, we welcome your comments and your questions throughout the presentations. So if you look on your screen, you can type any questions into the chat window in the bottom of your gray toolbar at any time. And Jessica monitors these questions throughout the presentation, and we will proceed to answer them after the remarks have concluded. So with that, I'm delighted to turn it over to Glenn to begin our webinar. Thank you, Glenn.
Thank you so much. It's a great pleasure, and thank you to Jessica and Professor Dar. Professor Dar has shown such amazing leadership for ASRM these several years. It's really a pleasure to work with her. So this is the disclosure slide. None of us have anything to disclose. That's always nice. My remarks are going to be drawn in part from this book I did in 2015 called Patients with Passports, Medical Tourism, Law, and Ethics from Oxford University Press. Although I use the term medical tourism because it's the most common in the literature, I don't mean anything pejorative. You could just as easily say cross-border reproductive care if you like. And it's useful at the very beginning to kind of distinguish three forms of medical tourism, medical travel. And by the way, at the bottom of the screen, you'll see those photos are from Bummengrad International Hospital, probably the industry leader, which I always like to joke looks like a very nice Marriott conference hotel, which many of us spend too much time. So the three kinds of medical tourism are: one, medical tourism for services legal in the home and the destination country of the patient. Some examples outside of reproductive technologies are hip replacements, cosmetic surgery. The second is medical tourism for services legal in the patient's destination country, but not the home country. Sometimes they call it circumvention tourism. Again, outside of reproductive technology, one example is travel to Zurich for assisted suicide. And lastly, medical tourism for services that are illegal in both the patient's home country and the destination country where they're going. The best example is transplant tourism for kidneys. Now, depending on where the patient is coming from, where the patient is going, cross-border reproductive care could fall into any of these categories. It could be merely people traveling for legal services where the main motivations are cost, queuing time, quality. It could be for things that are illegal at home but legal where they're going, where it's to circumvent domestic prohibitions. Or it could be things, sex selection is a good example, that could be illegal in both places, but a practice is available in one of the places. This kind of leads to the introduction and the organization of my book. You know, I will say that I'm going to focus on the chapter involving fertility tourism, but all the other stuff you see up here, quality of care, liability, insurance, the effect on destination country healthcare, these are definitely apropos of reproductive cross-border healthcare as well. But I'm going to focus on that which is distinct in fertility tourism. Okay, the first thing I want to emphasize is actually prevalence. And there's a couple of good studies I'm going to borrow from here. One is a 2010 study by the European Society of Human Reproduction and Embryology, ESHRE. Francois Shenfield and colleagues collecting information on female patients seeking reproductive technology services through medical tourism at 46 clinics over a one-month period in 6 European countries: Belgium, Czech, Denmark, Slovenia, Spain, and Switzerland, for a total of 1,230 patients filling out their forms. They extrapolated based on the schedules of the clinic. The clinics would perform between 12 to 15,000 cycles of treatment for fertility tourists annually, yielding an estimated of 11 to 14,000 distinct patients per year. While the patients came from about 49 different countries, there were 4 home countries that were heavy senders, collectively making up about 2/3 of the medical tourists. Italy with 31.8%, Germany 14.4%, the Netherlands 12.1%, and France 8.7%. In terms of where patients went, about 30% of the patients went to clinics in Belgium, about 20% to the Czech Republic, 12 to Switzerland, 12 to Denmark, 5.3 to Slovenia, 15.7 to Spain, and 16.3% to Switzerland. There were significant correlations between home and destination countries, suggesting the formation of reputational and referral pathways. For example, the majority of Italians went to Switzerland and Spain, while the majority of Germans went to the Czech Republic. Most Dutch and French patients went to Belgium, and most Norwegians and Swedes went to Denmark. In terms of the demographics of users, the authors found the mean age to be about 37.3 years, and the prospective parents, 69.9% were married, and the vast majority, about 90%, were heterosexual, although there was some variance by country of origin. So, for example, 82% of Italians were married, while only 43.4% of the Swedish women who used fertility tourism were single. And the percentage of users who identified as bisexual or gay varied from a high of about 40% of the French to a low of about 1.5% of the Italians, and 0 for those who listed their home country as the UK. In terms of the services sought, 22.2% of patients sought only intrauterine insemination, while the remainder wanted IVF and other technologies. Many significant portions of the fertility tours were using gametes or embryos from third parties, while about 18.3% of patients seeking sperm donation, 22.8% sought egg donation, and 3.4% embryo donation. The motivations identified by the respondents for using fertility tourism varied substantially based on home country. Legal reasons were predominant for patients traveling from Italy, Germany, France, and Norway, while difficulties assessing treatment were more often noted by UK patients than by patients from other countries. Most of the patients in the study suggested by legal reasons what we actually call circumvention tourism, so bans on donor gametes, bans on pre-implantation genetic diagnosis, bans on paying sperm or egg donors or for surrogacy services, as well as restrictions based on age, sex, sexuality, and marital status. And it is quite interesting to see that this was the main reason why most people travel. For the smaller set of fertility tourists who are not traveling for circumvention tourism, insurance coverage in the home country was the major driver. In a study published in 2010, we got some Canadian data, and these were sent to about 34 Canadian and 392 U.S. fertility clinics, studied by Hughes and Dijon in cooperation with SART and ASRM. First, they looked at travel to and from Canada for fertility services. They found that the most common service sought by Canadians out of country was IVF with an anonymous egg. About 363 out of 452 respondents, or 80%, said that's why they traveled. When clinicians in Canada were asked if they recommended particular destination countries or providers, 52% always recommended destination country, while only 21% always recommended a specific provider. When asked what factors they considered to be very important in making a recommendation, they mentioned confidence and effectiveness, that's 88%, confidence and safety, that's 80%, past experience of patients receiving care at the destination clinic, 64%, strong regulatory controls, 40%, and language, 40%. There was lots of variation in terms of, among other things, how often referrals actually occurred. When they looked at the actual U.S. clinics in their sample from across the world, they looked to see who came to U.S. clinics. And they looked at a total of 1,400 women who entered the United States to receive various types of services. They found that most out-of-country patients came to the United States sought standard IVF, with most of those patients coming from Europe, 25%, Latin America, 39%. They also found that of U.S. patients who went abroad for IVF or donor egg, most 41% and 52% traveled to India or parts of Asia. When asked what factors they considered to be very important in prompting non-U.S. patients to come to the U.S. for care, they listed confidence in treatment effectiveness, safety, and information from former patients. When asked what information they'd like to receive from home country clinics whose patients came to them for treatment, 84% of clinicians responded that track sheets from previous cycles should always be provided, as well as recent laboratory tests, that's about 85%, and complete medical records, 67%. Okay, so that's the data. Now let's just turn a little bit for a moment to the human side of this and take a look at some of the places where fertility tourism, in particular for surrogacy, occurs. We can talk more about this in the Q&A. Many have raised serious considerations and concerns about exploitation. The photos below are from the Akansha infertility clinics in Anand, India. So according to work by Scott Carney from 2008, it's a little out of date now, they had about 45 surrogates on the payroll. All the women had to be married and had to have at least one child and live in a communal compound away from her family. They were typically paid about $500 a month, plus $500 at the end of each trimester, and the balance upon delivery. All told, a successful Akansha surrogate made between $5,000 and $6,000, a bit more if she bore twins, and that's a significant revenue for a woman in India, especially the women from which they're recruiting. If a woman miscarries, she keeps what she's been paid up to that point, but should she choose to abort, an option in the contract, the standard contract there allows, she has to reimburse the clinic and the client for all expenses. So one set of questions we can discuss is whether this is a welcome opportunity for these women, enabling them to better their lives, or instead represents an unethical form of exploitation. Okay, this is my last slide. The other speakers are going to talk about this in greater depth, and the question is how to treat children born through surrogacy tourism for immigration purposes, and how to treat the activities in countries where hiring a commercial surrogate is a crime, which is much of the world, and part of why the U.S. is such a medical tourism destination for this kind of treatments. So consider the story of Samuel Ghislaine, who I write about in my book. born in Ukraine to a surrogate commissioned by his intended parents, Laurent Ghislaine and Peter Murrens. The men are married in Belgium, which permits same-sex couples to adopt, but they faced administrative difficulties that led them to surrogacy. They hired a gestational surrogate to carry a child created from Ghislaine's sperm and the egg of an anonymous egg provider. Upon the birth of their son in November 2008, Samuel's parents went to the Belgian embassy in Kiev, Ukraine, which refused to recognize the child as a citizen of Belgium. Because Belgian laws were silent on the legality of surrogacy, the Belgian government denied Samuel, the baby, citizenship, reasoning that it had no legal basis to recognize the Ukrainian birth certificate, despite the fact that the child's genetic father was a Belgian citizen. In what has now sadly become a common refrain, Samuel, baby, could also not be a Ukrainian citizen because Ukrainian law recognized the intended parents as the child's legal parents. So Samuel was neither Ukrainian nor Belgian citizenship, and without citizenship, he could not get a passport. He was stateless and thus could not leave the Ukraine. It took 2 years and 3 months to resolve the issue, with Samuel first placed with a foster family and then a Ukrainian orphanage until a Belgian court ruled in favor of Samuel's parents, wherein the Belgian Foreign Ministry finally agreed to give him a passport. At that point, after a long odyssey, Samuel was finally brought to Belgium. At the same time, this case did not set a precedent for the future. Following the resolution of Samuel's citizenship, the Belgian Foreign Ministry issued a press release advising against the hiring of foreign nationals because of difficulties in recognizing their citizenship. And as some of the other speakers will talk about, there's been updates in the European Court of Human Rights and elsewhere. But when you have a country that prohibits commercial surrogacy at home, it really has, the home country of the patient has to make 3 choices. The first is, should it criminalize the parental action in the home country? So should there be extraterritorial liability? It's a crime in your home country, say France, and you go to a place where it's legal. Should it be a crime in France to also go abroad to do it? And different countries have taken different approaches. Turkey, for example, for a time, criminalized AID done outside of Turkey. Second question is, do you recognize or not recognize the parentage of the home country citizens and therefore recognize that they are the parents of the child? And the third question that is related is whether you facilitate or deny the immigration of the child back to the home country. Typically, it's related to the second choice. So the other speakers will discuss in greater depth, and as Jillian in other cases, for example, the Baby Manji case, some Australian states prohibiting commercial surrogacy. These are real live disputes that every country that prohibits the activity at home has to face. And if you're interested during the Q&A, I can tell you a little about how I think these cases should be resolved. But let me stop there and turn it over to the other presenters.
Thank you. Ms. Desai?
Thank you, Professor Dar and the Ethics Committee for inviting me to join this seminar. I'm going to pick up where Professor Cohen left off and discuss some of the legal complexities in these intercountry arrangements. Some of the broad themes that we see throughout the last few years include this issue of comity, and I'll talk a little bit more about what that means in a minute. The legal security of children and families, so we see courts struggling to balance the public policy of their nation states along with the legal security of the children who are born of these arrangements. And then definitions of parentage, which I think helps explain a little bit about why it is that we have these disparate decisions depending on what nation state you're in. So let me start with this question. Why do couples leave the U.S.? We heard a little bit from Professor Cohen about some of the reasons that this happens. From my perspective, and I think the legal perspective, it's really more about finances and perceived ease of moving forward rather than anything else. So people have these notions that they will be able to leave the United States, pay a small fraction of what they would be paying here, and their surrogates will more likely than not be in supervised places where both their activity and their pregnancy will be monitored. We've seen, though, over the past few years that some of these centers have been closing, and we'll talk again a little bit more about that. So the evolution of this issues, which I think has taken perhaps the last 5 or 6 years, have centered around a few different themes. One is the ethics involved in all of these arrangements and the objections that European courts in particular have to these arrangements, case laws and decisions by foreign courts, and then I want to spend a little time talking about how to guide patients at the end. So the question I think that this slide raises is, why is it that a person can do everything right in one jurisdiction, enter into an arrangement with a gestational carrier, obtain a valid court order, and return home as the legal parents of the child under the jurisdiction in which the child was born, only to find out that her legal relationship to the child is not respected in her home state? The answer to this question at least starts with this idea of comity, the notion that amongst different nation states, and you'll hear me referring to states throughout this presentation because in international treaty parlance, nation states are different countries. So I'll use the words countries and states interchangeably, but we're not discussing different states within the United States. So comity is a principle that relies on the idea that we will have deference to foreign laws and courts. It's evolved over decades and centuries and really started in areas completely outside of this arena of law. And the point behind it was, in order to have a functioning world, we needed to respect the maritime space and trade regulations of one country as goods are entering into another. But the thing about comity is, unlike concepts in the U.S. like full faith and credit, it's not a binding legal principle. It's really a notion of deference, that if we respect the law of the other state, we are going to respect the court decisions made in those states. So there's been a flurry of activity, particularly in European courts lately, and a lot of it has centered around this idea of, when a child is born in another nation state and comes back to Europe, will that child be considered, number one, a child of the children, a child of the parents to whom the child was born, and number two, will that child be considered a citizen of that nation state? So in looking at these issues, the very first question the European courts have asked is, what, if any, conventions do we have that contradict the notions of surrogacies in other states? And remember that most of these intended parents are coming from countries in which surrogacy is not legal. It's not a path to parentage in their homes. So the courts have really focused on the European Court of Human Rights, who have heard the bulk of these appeals, have really focused on Article 8 of the Convention on the Rights of the Child. And that convention states first that everyone has the right to respect for his private and family life, his home, and his correspondence. And then second, we're not going to interfere. There's going to be no interference by a public authority by the exercise of this right, except in accordance with the law and is necessary in a democratic society, in the interest of national security, public safety, and economic well-being, for the prevention of disorder and crime, and then for the protection of the rights and freedoms of others. And that's really one of the key elements here. So there was a number of cases that came down at the same time that were heard by the European Court of Human Rights. The two cases that I'm going to focus on right now had similar fact patterns. So the lower court was refusing to recognize parentage of couples who had come from Europe and gone to California in one case and Minnesota in another. So in the Meneson case, the children were born prior to the pregnancy. The intended parents had entered into an arrangement with the gestational carrier. The babies were born, and then a court order was entered, and the children's birth certificates were entered with the intended parents' names on them. So the intended parents went home, and they registered these birth certificates in France. The public prosecutor later sought to set aside this registration and the French courts actually granted that. So in the sister case, the issue here was the Minnesota birth certificate was never registered with the registration office in France because the public prosecutor had refused already to even recognize it. So we've got two situations here in which we have children with no valid registration. And for those of you whom it would be helpful to hear this, in European countries, many of the rights and privileges flow from a formal registration of the children. So there are social benefits, health insurance, school, a whole host of benefits that we don't really have an analogous process in the U.S., but it's absolutely critical in order to be granted both citizenships and rights and privileges in their home countries. So the question becomes, what happens in these situations? And when the U.S. looks at these situations, they take the following position. Regardless of what court order was entered in another country, if both parents are citizens, then citizenship can be granted as long as one of the parents resides in the U.S. prior to the baby's birth. And if only one of them is a citizen, then there's a further residency requirement. But the most important part of this is that there has to be a blood relationship established through clear and convincing evidence. So the child will have U.S. nationality at the time of birth, but only if, and this is the way the statute is written, although it has been extended in cases to mothers as well, but only if the blood relationship exists. So if there is a laboratory error or something happened that wasn't expected, or you have donor egg and donor sperm, a child won't necessarily qualify for U.S. citizenship, and they may end up as a stateless baby, meaning they don't have citizenship in the country in which they were born, and they don't have citizenship here. So back to the European courts, the courts have really been balancing the public policies of the states with the interests of the children, and you see over and over again, they're not really very interested in the rights of the parents in all of this. So what happened in those two cases is that the court eventually found that there was no violation of the rights of the parents in this case. It was really a violation of the rights of the children to have a relationship with their parents. And so with that, once the European Court of Human Rights spoke on that issue, we have a governing body that is an umbrella for many of the different nation states in Europe that are part of the treaty that binds them. So for any of those countries, they have to look to this decision before refusing registration for a child. So now it is a little bit easier for many of these families to establish parentage and citizenship for their children, but the issue remains a significant one because depending on what state you're in and depending on what court you're in front of, you may or may not be able to get valid citizenship for your child, nor will a court necessarily confer legal parentage on you. So this brings us to what the Hague has been doing. The Hague has been thinking about a treaty similar to the adoption convention that we have that would really regulate surrogacy. And so the question that they first asked in 2012 was about multilateral cooperation, meaning what is it that we can accomplish through this treaty? So they've decided that there are several needs that they're trying to meet. One is child protection, one is protecting surrogate mothers, and then the third is exploiting vulnerable intended parents throughout this process. There have been a series of meetings throughout the last few years, and the most recent findings have really focused on a few things. One is that we need further work to be undertaken, and we need to figure out how to unify private international law rules regarding legal parentage. So as the Hague has been meeting with members of various nation states, they've been finding that the norms in each state are so different that we can't even come up with some sort of consensus as to are there situations in which surrogacy is ethical? Are there certain safeguards you can put into place? So after establishing an experts panel, the question has become, maybe the focus needs to shift, and perhaps the focus might be on respecting parenting decisions, and so the next meeting I think is going to further explore that idea. If and when we do have the Hague Treaty, it will provide some guidance for people who are traveling in other countries as to whether their parentage will be respected when they come home. So I just wanted to spend a minute talking about how other countries are reacting to this. In Thailand, in February of 2015, the legislature passed a law criminalizing commercial surrogacy and included a possible jail time of 10 years and $6,100. Very recently, India has even closed doors to persons of Indian origin who are not residing in the country. So we're seeing a closing down of many, many countries. One country closes, another one opens, and so we're seeing pockets around the globe of countries who are entering into surrogacy arrangements. The last that I want to leave with you is in the United States, there's a patchwork of legislation, and some of it allows for surrogacy under certain conditions. Others do not allow it under any circumstances. But the question that the state legislators have really been striving to answer is there a way to do surrogacy legally and ethically? I think that we found in Illinois that there is, as long as there are safeguards in place to protect the intended parents, the surrogates, and most importantly, the children born of these arrangements. Surrogacy can be done in a way that's ethical and safe, but until we start finding ways amongst various countries to come to a consensus about what those safeguards are, we're not necessarily going to have a framework in which it's safe to be traveling to other nation states to have your children. Thank you. I will pass on the presentation at this time.
Thank you. Dr. Davis, I'm going to pass this to you.
Well, thank you very much, and thanks to both the speakers and, of course, Dr. Dar and Jessica for organizing this and inviting us all to participate. I think it's a wonderful topic and very timely with, you know, lots of different aspects of what's going on in the media and what's going on with politics, to say the least. You know, my intent as sort of the clinician representation to the panel here was to be able to give a little bit of a different clinical perspective, specifically to touch on some of the ideas behind some of the elements to consider with regard to clinical practice and cross-border reproductive care, but also to demonstrate some examples of scenarios that might pop up within clinical practice. Granted, this cross-border, of course, is, as the name implies, crosses all the different borders for countries across the world. Admittedly, the cases are presented a little bit from an America-centric standpoint, but could be presumably applicable to practice in other countries. But sort of coming from the country that I'm practicing in, from that perspective, the title "Globetrotting Patient Clinical Scenarios" is exactly that. We have patients that, a lot of the discussion to this point has been about specifically about surrogacy, or specifically about sort of, the legality of the recognition of the birth of the child in the different countries. But we also have patients that will travel for services or travel to other countries to receive care, or people coming to the country to, so donate eggs and so forth. So these are all different elements to kind of keep in mind when we're talking about cross-border. It's a broader topic as far as people accessing it, care in other countries for different reasons. One of the particular scenarios that I wanted to present is, well, actually, let me take it back one step here. One of the things to keep in mind with regard to cross-border care, and this was touched on a little bit in Dr. Cohen's component, is some of the main reasons that people undergo cross-border care: increased access to services that aren't provided locally, cost of services, either significant cost reduction by going to a different country, or just in general cost of different services being more affordable, regulation, and this we touched on with the legal aspects, but also privacy. Some people have been shown to undergo care in other countries because they just need some sort of privacy for their particular situation that they're going through, be it avoidance of family knowing of their particular needs or situation that they're undergoing, because in certain cultural situations, different members of the family may be more influential in decision making, and if a couple feels that they need some privacy from that matter, then this is another reason that people would seek care elsewhere. One of the main underlying causes behind all of these, of course, is the public policy and healthcare funding not prioritizing fertility as a major factor. And infertility has been defined as the WHO as a disease that causes disability, and the burden of disease from infertility is estimated at over 186 million people worldwide have infertility, subfecundability, or involuntary childlessness as of 2004, which the data is always a little bit challenging to collect on that, but it's a significant burden on public health as far as people that are afflicted with challenges in becoming and completing their family. And because of the diversity of the availability of resources and access, as well as legal prohibitions in certain countries, people find the need to go elsewhere to get that care that they can't get in their local environment. Some of the specific benefits of cross-border reproductive care that, again, we'll mention and we'll kind of cross over with some of these cases is improving access to care, reducing the cost of care by going to other environments, avoiding discrimination, such as the example given of traveling to avoid discrimination for either gender identity or sexual orientation, to name a few. Other benefits, though, are enhanced revenue streams for the countries receiving the patients and providing the care. In some places, this is a significant boost to the economy, the local economy, that otherwise may not have a lot of thriving economic growth. And of course, protecting privacy of the individuals. Some of the harms, though, to keep in mind are, of course, health and safety of the providers, of the patients that are undergoing it, particularly gestational carriers as well. We talked about some of the other potential harms are with language and legal barriers comes challenges. In providing good quality care, you have to be able to understand what's being offered, understand the components of contracts and the legal applications, as well as to be able to truly consent to a procedure, especially something like assisted reproductive technologies. You have to understand what's being done, and if there's a language barrier, that can be very challenging for people to ensure that that understanding. Also, of course, harm to the individual the stakeholders, the offspring, the donors, the surrogates, and potential harm to local population, although I mentioned previously a benefit is enhancing revenue streams, but there's also a potential for the other direction to have harm to the local environment. So the first case I wanted to mention is an example, and again, these are not intended to be all-encompassing examples, but just sort of some demonstrations of, for example, a 29-year-old French woman with a female partner presents to a U.S. clinic for donor sperm insemination. And the idea behind this particular scenario is, of course, that legal restrictions in countries such as France that prohibit access to insemination for persons of particular sexual orientation or gender identity, it basically means that they can't get care in their own country. Even though care may be readily available as a resource, it's not available to this particular population of people. And as Dr. Cohen mentioned, there's some good statistics on who's getting care where and to what extent. We know that in the U.S., about 4% of fertility treatments have been shown to be provided for non-U.S. citizens. So it is a small but significant portion of care being provided in the U.S. And 55% of European patients that travel abroad were for the purposes of law evasion. And these numbers, again, of course, are potentially different between different studies, but basically emphasizing that this idea of traveling to another country to get care that you're otherwise legally prohibited to is a significant portion of why people travel. The concerns, of course, as were mentioned, are what happens when the couple returns to their country, as far as the protections of the patients and their offspring, and some of the issues with regard to the laws that we've just talked about in the previous speaker. So again, one example. Another example of a case scenario that some may find is an attempt to sort of reduce the cost of care. This is a case where after several failed fertility treatments at a clinic, presumably a U.S. clinic in this scenario, a couple informs you that they're planning to have IVF in another country because it's cheaper. and they want to know if you can send your records on, but also they want to know during the treatment course, because presumably they're doing their care across 2 countries, with some of the care being provided in the U.S. and ultimately going to the other country for their either their oocyte retrieval or their embryo transfer, what have you. They want their current provider to weigh in on their treatment management to make sure that they feel that they're getting their care is overlooked or overseen. Part of the trouble in this particular scenario, of course, which may come up, is that as a provider, you want to be able to counsel your patients on the best possible options and to make sure that they're well informed. And that would be for any medical provider in the world. You want to have the patient have autonomy. In order to have autonomy, they have to have an understanding of the care, and then we have to ensure the quality of care for them. It would be impossible for any provider to know every clinic in the world's quality and reassurance, being able to reassure the patient that where they go is of top quality without, there's no possible way that any individual provider can know all that. So we're challenged with that question by the patients of, oh, I want to go to the XYZ clinic. Are they going to take care of me? Is it going to be good? And we may not know the answer to that. But the important thing is ethically, of course, to inform the patient that, I'm not familiar with that. I can't comment on that. The second part of this, of course, is that it's hard enough for a patient to, follow through with their care when one provider is working directly with them. When you have a second provider that is also weighing in on it, there's a potential for mixed management and complications. So although it makes logical sense if it's a patient that you've been working with for several months or years and they're seeking care elsewhere, that you want to still be involved in care for them, but it adds a lot of challenge with co-managing. So it's really important to basically advise the patient that you need to separate your practice from the practice that they're going, and you're happy to be available to them for mandatory test, lab results or ultrasound to get labs drawn for them, but that you're not able to adequately co-manage them without being a part of the practice that is also working for them. Another thing, of course, in counseling patients who undergo these, who decide to go travel for their care, is just to give them general advice about being safe when traveling, making sure that they know the areas that they're going to and that they've done their homework on the practice that they're going to. Even if we don't know individual statistics or numbers on the patient or the practice that they're going to, we can at least advise them on general good decision making. Third case I put in here really just to sort of touch on the sort of media charged aspect of it. An agency contacts a provider and requests that he provide third-party reproduction assistance for a couple from China who wishes to have their baby born in the U.S. by a gestational carrier. Of course, this has got a lot of sort of politicization of it in media, but it's an important factor to keep in mind that there are many different countries that don't allow for paid gestational carriers. And as a result, it's a limited resource, and it's challenging to get adequate care. U.S., India, Thailand, Ukraine, and Mexico are ones that are known to allow for paid gestational carriers. However, many other countries don't, including China. And so this is a situation that people that have a limited access to this particular service, if they need it, would want to have that opportunity. The other sort of perspective that a lot of people or many people will potentially overlay is is there an ulterior motive here as far as citizenship? And it's important to have that conversation with your patients and to have an open discussion about the medical side of things, and not to put undue presumptions on top of the relationship. And again, the same questions, concerns that we discussed earlier as far as legal status after birth and citizenship for the child once they, depending which country they deliver in. And that's the other thing to keep in mind, is the difference of where the country of origin of the intended parent is and the country of delivery of the child makes a huge difference as far as the overall implications to the child. Another case, again, this is the question of a 37-year-old using a gestational carrier because she's had a cesarean hysterectomy and no longer has a uterus. Found that she looked within the U.S. and found that gestational carrier seemed to be out of price range, but she found a less expensive program in India and is asking for advice on should she do this or not? Again, issues with regard to gestational carriers we've discussed a bit in the previous two sessions, so I won't belabor that. But some reports say that third-party reproduction is the most common reason people travel abroad for various reasons, either cost or accessibility or legal restrictions. And things to bear in mind is that different countries will have different regulations as far as screening of carriers, and as providers in your home country, you may not be aware, and you're not obligated to be aware of all those different changes in the different countries. But again, informing the patient that, in this country we do this, this, and this, something that you may want to ask your provider about, but you aren't expected, and it's really sort of not appropriate to give presumptions of aspects of other countries' care and laws without being directly knowledgeable about that, and just to be straightforward with the patient. Final case really is a traveling egg donor. This is a 39-year-old woman with ovarian insufficiency following chemotherapy request. In your practice, to use an oocyte donor who she found on a Russian website because she's willing to come to the U.S. to do the oocyte retrieval, and it was much more affordable for her. And this is an aspect that I don't feel like we've touched much on in the previous sessions, but the concern for the safety of the donor. She's presumably doing this altruistically or with some intention of making cost to cover her costs. But there's also the realistic concern of trafficking of donors, of people having young women who are in vulnerable positions that are susceptible to exploitation due to their particular situation where they're living or what environment that they're in, and they may be essentially shipping them out to other countries as a way to make money for a third party, a broker, if you will. The other concern is bait and switch of people traveling to do oocyte donation, and they have this profile of what their oocyte donor is going to be, and they get there and they're not aware that there's been a change of plans. And when language barriers come into the issue, that's another concern, that if a patient is not able to understand the language of the providers, then it makes it much more challenging. Again, the important key components are to make sure that patients have autonomy and can make informed decision making, and that really requires understanding the language of the contract and understanding the language of the providers so that they can have an open conversation. And finally, there's the other question of if a patient is harmed in this travel to either another country or if they're traveling to this country, the legal recourse within their home country for whatever that injury may be could also be challenging for the traveling patient to really be able to track down. So that's the main sort of clinical scenarios I wanted to present. And of course, one of the ideas of this was to open up the conversation for the other two speakers to weigh in on any of these particular situations if you felt that there was something additional to contribute, or just to open up to the questions that we've had people been sending in.
Hi, this is Jessica. The first question in is, how is the U.S. dealing with this? Any leadership on this topic?
This is Glenn. Let me jump in. I think largely the answer is no. If you're talking about political leadership, I don't know if the others have different thoughts. And as was mentioned, actually, there's a split of opinion between the way in which the State Department and the USCIS handled some of these cases. So it might matter whether you have a child that's come in where you've applied for the visa from outside versus a defense and a deportation hearing.
Hi,
Go ahead.
Go ahead. This is Nidhi, and I was going to say that I think that because surrogacy is regulated state by state, there's some role that the federal government can play, but not a huge one. We do have a representative from the State Department that is at least participating in the Hague talks, but whether or not we ever have a treaty is another question entirely. So I think in part it's really not a federal issue. We don't have that much federal involvement.
And finally, this is Judy.
Say this is Joe Davis. If you want me to weigh in on it as well here. So one of the other components to keep in mind too, as far as making in this, from a global perspective, infertility has not really been prioritized on a public health sphere as much as it really should be. And a lot of different countries with different regulations on the different aspects of infertility care in some ways don't have a great incentive to alter their prohibitions, particularly for couples with same-sex relationships or single patients, that if it's prohibited in a certain country, there's nearby countries that have resources that are available to them, and so there tends to be not a lot of strong political motivation within that country to make that resource available in certain situations. Granted, that's not always the case. There are many countries who see it as a major factor that they want to either reclaim that those patients or reclaim that potential revenue. But again, the fact that there's such diversity of political climates and legal systems around the world, and that travel is so readily available, there doesn't seem to be a big push overall for standardization, which really the first step, of course, beyond recognizing infertility as a significant disease-causing disability, is to make sure that there's a standardization of quality of care globally for patients' health, and to make sure that if they do travel, which they will, that they're not being put in harm's way due to economic constraints.
I have another question from the audience. Can patients get partial treatment in the U.S.? Say if they're doing egg freezing or IVF abroad, can they be monitored in the United States before the cycle? A follow-up question to that is, can you transport sperm overseas?
Let me answer the second part. You can transfer sperm overseas, and indeed there's a large amount of sperm importation that happens, especially for countries where donor anonymity is prohibited. And one of the big jokes is that actually Denmark is one of the largest exporters of sperm, so much of the world is carrying Danish genetic babies.
And perhaps, Dr. Davis, could you answer whether you can perform the initial testing before they go, the monitoring?
So yeah, that is possible. I would say it is done quite frequently, both from the U.S. and also in reverse, that patients traveling, especially with regard to IVF and with the whole process of stimulation of ovaries and collection of oocytes and embryos, the majority of the initial laboratory testing can be done essentially anywhere in the world that has a certified lab, and the monitoring with ultrasound likewise could be done, whether it's a patient living abroad doing the monitoring and then going to the country of which they're going to have the retrieval. The more challenging part, much like the question of the transporting of sperm, is once the embryos are created, there are going to be challenges as far as transporting embryos, either across borders or just the logistics of maintaining the chain of custody of the embryos from a safety standpoint. And an important factor to think about that is that I mentioned quality, that there are certifying bodies such as JC International, Joint Commission International, that is, an important internationally recognized body for ensuring quality of care. And so for patients that are interested in doing that split care between one facility and going to another, it's important for them to be knowledgeable about what certifications to be looking out for before they undergo care in two different facilities.
But let me just jump in there and slightly disagree, which is I think the JCI accreditation is good and better to go to one that has one than doesn't. But it doesn't, for example, give you what the CDC requirement of reporting outcomes is, just that you compare readily, successful cycles and stuff like that. Now, of course, there's some problems with the CDC one as well, but it's just to say that I think as a consumer thinking about going abroad, you face some pretty deep informational deficits.
Oh, absolutely. I agree 100%. And that's, CDC and SART, very important, of course, for from the U.S. standpoint, but there are other organizations with ICMART and Red Lara that are monitoring quality in regions that they do. But you're right, there's a very large portion of the world that is just not reporting their data, and to rely on websites or other sort of practice-derived numbers without an overseeing monitoring body can be problematic. So very important point, and I'm glad you brought that up.
Another question from the audience. I'm finding many donors are by far exceeding the ASRM recommendations to limit to 6 cycles, some of whom have done upward of 10 to 18 cycles and traveling the world to provide eggs in different places. What is the obstacle to starting a registry, either nationally or internationally, to track donor cycles?
This is Glenn. I'll jump in and say, so far we've had great difficulty establishing registries in the United States, so I would think that actually trying to do it internationally would be even more difficult. Among the concerns is how much information are you sharing? Is there concerns about anti-competitive behavior? And I think registries would be lovely, but the experience in the United States has not been that good. I don't know if the others have a different view.
Yeah, I agree with you. I don't see the United States anytime soon starting a registry. I know there was some talk of it, and there is a possibility of setting it up under various existing data collection sites, but the fears of, number one, as you mentioned, the anti-competitive issues, and number two, HIPAA violations and privacy concerns have far outweighed so far the drive to have one done.
This question is for Ms. Desai. I'd like to know more about what the Hague is doing.
Sure. Well, the Hague in 2012 started down a road of trying to figure out whether there's some way of entering into a treaty that would do several things. One is to protect the interests of gestational surrogates who are going through this process. Two is to protect the intended parents, and then I think most importantly to protect these kids who are born, to make sure that they do have a path to citizenship and parenthood. But what we found is, and it's still in its infancy, this process, the last meeting was in February, but what we're finding is that there is such a great divergence of opinion as to what is ethical, as to what is acceptable, that it's hard to find points of consensus among different countries, whether it be European countries and American countries, or India or China. So I think it's going to be very slow coming, and finding those common elements, those points at which we can agree, are going to be critical to determining what, if any, form the treaty takes. So right now they're reflecting on the meeting that just occurred, in which they had a member representative from each country, and trying to decide what the next steps are. So feasibility is one of the big issues in all of this.
And for our last question from the audience, I'm from Newcastle in the United Kingdom, and wondered, with mitochondrial replacement therapy on the horizon here, what are your views about cross-border reproductive care for mitodonation, especially if it's not yet available in the United States?
This is Glenn. I do think we will see some cross-border travel for mitochondrial replacement therapy to Newcastle. Of course, you know, you guys originated it. So even if it was available in the United States, I think the expertise that you bring would draw patients.
Well, in that case, I have time for just one more question, and that is, what is the current status in China regarding laws restricting the number of children a family can have?
Well, my understanding is the one-child policy has been lifted, and so I don't think that there is an official policy as to whether there's a number, and someone can correct me if I'm wrong, but it's only been a couple of years since that's happened, so it's very much in its infancy.
Thank you very much. And that concludes our webinar today. Thank you to all our presenters and attendees. The session was recorded and will be available on our website in the near future. Please keep an eye out for announcements of our next webinar topic for September. For any further questions or comments, please don't hesitate to contact me at ASRM@asrm.org. Attention, Jessica. This concludes our webinar.